And in the original opinion, I said that if at any time any of the parties felt, especially the plaintiff, that the terms of the master plan, which were incorporated in a final order, were not being implemented, then come on back. Lay out with some specificity what is not being done, what is your recommendation as to what should be done, and then move on from there. All right. That was not done until approximately 1995 or 96. So here you have 81 to say 96. That period, you presumed, simply by the silence of everybody, that it was being implemented. Now that may be a conclusion which was erroneous, but that's, judges react to what is before them. I don't look around and go, let's say, down to Monroe County and say what's being done here and then move accordingly. It doesn't work that way. Right. Ultimately, what happened was in 2001 or 2002, I changed that opinion. And it was based upon a statute that was passed by the legislature that basically said that what we are going to do is that we will examine the results that we have in all areas of education which are touched upon in the master plan. See, based upon test scores and their whole series of criteria as to how you measure success. And those areas in which there may be a deficiency, then we will concentrate on those. Instead of showering the money up front, we will do it the other way. We will come in the back door and say, okay, we need money because we don't have enough math teachers. We need resources because we don't have enough science equipment, that type of thing. And instead of just an overall approach, it would be a ad hoc, dedicated approach based upon what the legislature said they were going to do and how they had the ability to go out and to qualitatively assess what is going on. So the decision basically was reversed. And I dismissed the case at that point. I said there's no reason to keep it on the docket as I did the first time. I said, however, if anybody feels that somehow there is a need to implement this opinion, there are ways, procedurally, where it can be done. And that's by writ of mandamus or all kind of ways to do that. That has not been done. So once again, you sit back and say, okay, the opinion's been out there for nearly 10 years. And nothing's been filed suggesting that we have a problem. I must then assume that everything is fine.